You ever wonder what happens when a homeowner thinks their HOA is hiding something? Well, we're going to dive into a real-life legal battle that started with a pretty simple request for financial records and ended up in a formal court hearing. Let's break this all down to see what went wrong and, more importantly, what we can all learn from it. I mean, wow. That quote right there from the homeowner, Katherine Belinsky, tells you everything you need to know about how she was feeling. It just perfectly captures the level of frustration that led her to file an official petition against her condo association. She clearly felt completely powerless. So, what's this all about? Well, it really boils down to two key things. First, a homeowner who just wanted to see the financial records, and second, a surprise $5,000 special assessment that hit every owner in the building, seemingly out of nowhere. All right, so let's start with the homeowner side of the story. What exactly pushed Miss Belinsky to take such a huge step? According to Miss Belinsky, this wasn't a new problem. She testified that she had been trying for years to get these financial records. She felt completely stonewalled, claiming her requests were just ignored again and again. You can see how that would lead to some serious suspicion about where her money was going. And look, these weren't vague requests. She was asking for very specific things: bank statements, contracts, invoices. The exact kind of documents anyone would need to get a clear picture of their association's financial health. And this, right here, this was the core of her testimony. Ms. Belinsky stated, under oath, that she never got what she called legitimate, real bank statements. For her, this was proof that something was being hidden. Okay, so that's one side. But every story has two, right? Let's flip it and see how the HOA and its board members responded to these really serious accusations. The board's first point was some pretty shocking context. They testified that the building's reserve account, that critical savings fund for big repairs like a roof or an elevator, had only $1,000 in it. Just $1,000. For a building built back in 1969, that is dangerously low. They argued that the $5,000 special assessment wasn't some random choice. It was an absolute emergency. Now, this is where things get complicated. The HOA presented this timeline, which shows a very different story. They provided evidence of multiple emails sent in just 1 month, March 2022, that directly contradict Ms. Belinsky's claim that they never responded at all. And this, right here, was the linchpin of their whole defense. They argued that they had repeatedly offered Ms. Belinsky the chance to come in and review a full packet of all the records at the property manager's office, which was literally just minutes away from her condo. So you see the problem, right? You have two completely different stories, both told under oath. On one side, the homeowner says she never got legitimate statements. On the other, the judge's official finding of fact says that bank statements were, in fact, sent to her on March 4th. So, who did the judge believe? How do you untangle two versions of the truth that are so far apart? Let's get to the verdict. But before we get to the final ruling, there's a key legal idea you have to understand. It's the concept of reasonably available. See, the law in Arizona doesn't say an HOA has to email you or hand-deliver every single document you want. It just says they have to make those records reasonably available for examination. And that little distinction, well, it turns out to be everything. So, with that legal standard in mind, the judge's decision was pretty straightforward. The homeowner's petition, it was denied. And really, the entire ruling boils down to this one simple sentence from the judge. Ms. Belinsky had the burden of proof. She had to prove she was denied access. And, well, the judge concluded she just didn't do that. So it all came down to this simple point. The HOA didn't have to email her everything she wanted. By repeatedly offering her the chance to come look at the records in person, an offer she never actually took them up on, they had legally done their job. They had made the records reasonably available. Okay, so what's the big lesson here? Let's distill this down to the key takeaways for anyone who lives in or is thinking about living in an HOA. Beyond this one specific messy conflict, what are the universal lessons that we can all take away from this whole thing? All right, there are 3 really big takeaways here. Number 1, document everything, always, in writing. Create that paper trail. 2, if your HOA makes a formal offer to let you see records, you have to follow through. Not responding can be used against you. And 3, understand the law. Knowing the difference between providing records and making them available
could be the thing that wins or loses your case.
And that leaves us with this big, final question that really gets to the heart of living in an HOA. Where does the board's responsibility to give you information stop and your responsibility to actually go get it begin? This case perfectly illustrates that very fine line, and it's something every single HOA member should probably think about.